Welcome back everyone to our studies in business law and practice for the SQE specification. We are still continuing looking at the various different business and organisational characteristics, the distinction, the delineation between the sole trader, the partnership, the LLP, the private and unlisted companies, all of the above. But what I want to do in this video is spend a bit of time just expanding on and expounding on some of the issues that we were looking at in the previous video when we looked at the idea of the company. And this is to focus on the basic ideas associated with separate legal personality of the company. What this actually means, where this principle comes from, a little bit of reference to a bit of case law, and what this principle talks about in terms of some of the consequences of this kind of principle. Because the SQE specification doesn't really give any recourse or any, there isn't really much time spent on one of, in my opinion, the most important principles, fundamental principles of the company, which is the idea of the corporate veil and associated with the piercing of the corporate veil, or the rules associated with that. That's a foundational chapter in all of the textbooks for general company law, but it is not a foundational principle for the SQE, as it turns out. So I'm going to spend a bit of time talking about it, but that will represent extension material, as you can probably imagine. So, the concept then of separate legal personhood, the concept that the company has separate legal personhood, is something that is foundational to the very nature of a company itself, to the very definition of a company itself. It forms the heart of the incorporation process, and the leading case that is associated with establishing this rule is a very old case from 1897 of Salmon & Salmon and Corporation Limited. This was fundamentally a case in which Mr. Salmon was a sole trader in a business, so he ran the business, he was the business itself. But then he decided that he wanted to create a new company for the business, and then decided to sell his sole trader business to this company. Now remember, a very important point, that when you create a company, you're creating a new thing in law. You're creating a new person in law, if you will. It's creating something that has separate legal personhood. So you can create a company and then sell your business to the company that you have just created. So Salmon was a sole trader. He has some assets, let's say, for his business. He then creates a company and sells those assets to that company. Now, in reality, practically, Mr. Salmon sitting in his office or whatever, that might not look like anything really, because he's selling this stuff to his company, which he himself is the director of, so nothing really changes practically. But in law, the business assets are now sold to and now are owned under the auspices of this new business. The sale of the business, the sale of the sole trader business to the company, was done in return for £10,000 in debentures, which were secured by a floating charge. We'll get to all of what a floating charge is and what debentures are in future videos, definitely when we look at things associated with liquidation and things associated with debt and equity finance and all that kind of stuff. Don't worry about that for now. But in addition to this floating charge, he gave a number of his children shares. The reason why this was the case is because at the time, in 1897, it was required that a company have at least 7 members. Luckily, that has now been reduced down. You can have a company with a single individual these days. But at the time, the company had to have at least 7 members, so he gave all of his children different shares in the company in order to actually make it all work on paper. When the company then went into liquidation, it went insolvent, it was unable to pay its debts when they fell due, and therefore it went into insolvent liquidation. Solomon was able to recover that £10,000 that he had sold his business for from the floating charge, but there was very little left in the way of assets to pay off creditors. So essentially, when a company goes into liquidation, there is essentially a long line of creditors, people who you owe money to as a business, that want some of their money back. And when you go into liquidation, you sell off assets and all these different kinds of things. The company breaks down and all the assets that are left are sold off, and they are sold off, and then a liquidator, the person who is essentially associated with running and managing this operation, has to then pay the creditors the best way they can. And you might have thought, well, surely if the company goes into liquidation, this £10,000 that is secured by a floating charge, well, that surely should go to the creditors, given the fact that that would pay off some creditors. That would pay off some of the people that the Salmon business, Salmon and Corporation Limited, owed to these people. Well, this is really where we get into the crux of the issue of separate personhood and separate legal personality, because the liquidator thought exactly that. They said, look, we want to make it the case that this £10,000 was to be paid to the creditors when we wind up this company. And therefore, Mr. Salmon himself is personally liable for the payment of this money to those creditors. Well, the House of Lords would disagree with that assessment. And they disagree because Salmon was not personally liable for the payment of creditors on behalf of the company. They were two separate things. Mr. Salmon was the person who ran the company, but the company itself was a separate entity in law to him. And therefore, the debts which were owed to the creditors were owed by the company, and they were not owed by Salmon himself. Any of the assets that were on the balance sheet of the company could be sold off and given to the creditors, but that £10,000 in the floating charge, remember, Mr. Salmon sold his sole trader to the company for that amount. That was his money, that was not the company's money. There are two different things, okay? And that's what the House of Lords established. Now, one of the consequences of this rule is this idea of a corporate veil. The logical extension from this case is the concept, firstly, of limited liability, the idea that members of a company themselves are limited in their liabilities for debts that are associated with the company. And so Mr. Salmon himself, for example, is protected against having to owe all that money to his creditors, but also this idea that you could shield yourself from liability by using and wielding the power of the separate legal personhood. This is sometimes known as the corporate veil, and usually it's a good thing. Usually it's a good thing because it allows people who are running a company to take certain risks with a company, to make business decisions without fear that they are going to be held personally liable. It allows the company to represent itself as an entity in law rather than the people who run the company. It allows for people to come in and out of the company and the company itself stay as a stable, consistent entity. And so for the most part, most of the time, this is fine. But in certain circumstances, members of a company are able to abuse this system to try and shield themselves from liability. And this shielding is known as a corporate veil. And in certain circumstances, the courts and Parliament have developed principles where they are able to disregard the corporate veil and attach liability to the members themselves and so-called pierce the corporate veil. Now, courts and Parliament have been very, very careful to limit as much as possible the situations in which they are able to lift the corporate veil or pierce the corporate veil, because if it becomes easy to lift or pierce the corporate veil, then every single time a company goes into liquidation, they will be able to just lift the corporate veil in all circumstances, and then the idea of the company as an entity itself, or the idea of the limited liability company as an entity itself, ceases to exist. So you have to be very, very careful with balancing the circumstances where it's probably a good thing that the corporate veil is pierced so people don't abuse the system, but that you don't pierce the corporate veil in all situations, because then that will just reduce the idea of a company back down to a sole trader, essentially. Now, the most recent case on this matter is Prest, and this is representative of extension material. I believe the textbook cites Prest very briefly, just as a sort of throwaway comment. So if you feel like you don't want to or need to or care to go through and have a look at this case, then that's perfectly fine. You don't necessarily need to understand this case or the facts of this case and the rationale for this case to understand or to do well on the SQE, for example. But fundamentally, the case of Petrodale Resources versus Prest from 2013 is a case that arose from divorce proceedings between two individuals, as you can imagine, between a certain Michael Prest, who was a wealthy oil trader, and his wife, Yasmin. During the financial settlement of their divorce, Yasmin sought to get a share of the matrimonial assets, as any divorce would entail. Among the assets were several properties that were held in the names of companies that were owned and controlled by Mr. Prest, including this company, Petrodel Resources Limited, and other associated companies. These companies were registered in offshore jurisdictions, but they were effectively controlled by Mr. Prest. Just count yourself lucky that you don't have to spend too much time thinking about the international dimension of company law, because it gets a bit messy and very difficult to regulate. Yasmin Prest argued that the properties were held by the companies that were that she argued that the properties that were held by the companies were beneficially owned by her husband and therefore should be transferred to her as part of this matrimonial settlement. Essentially, she was arguing, Mr. Prest was arguing, should I say, that these companies fall outside of the remit of the matrimonial assets settlement, whereas Mrs. Prest, soon to be Miss Prest, believed that they should fall into this and therefore she should get some of the spoils. Now, this was a case that, of course, went to the Supreme Court. In the High Court, at least initially at first instance, it was ruled in favour of Yasmin Prest. The court found that the companies were holding the properties on trust for Michael Prest, that a resulting trust existed as the result of this, settlement and of this arrangement, and that they ordered the transfer of the properties to his wife. The judge concluded that the companies were being used as what we call a sham, essentially a way to avoid liability for the divorce settlement, and that it would be just and proper to pierce the corporate veil to achieve a fair result. Simple as that. The Court of Appeal, however, overturned this decision, holding that the properties were owned by the companies. The properties that Mrs. Prest was going for was owned by the companies and not Michael Prest personally. Now, of course, she wasn't getting the divorce from the companies, so why would those assets be part of the matrimonial assets settlement? That was the ruling and the decision of the High Court. And really, the question that reaches the Supreme Court is whether or not these are assets that are being effectively owned by Michael Prest, and that he is using the shielding of the companies to essentially protect those assets from being taken from him, because, of course, of this idea of corporate liability, the corporate veil, and separate legal personhood, or whether or not because they are part owned by a different company, they're owned by the company, that they shouldn't be part of this matrimonial asset settlement. And the Supreme Court was appealed to the Supreme Court, and they issued a judgment in 2013. They held that the financial settlement should result in favour of Yasmin Prest, but adopted a different rationale to that of the lower courts. Importantly, they didn't necessarily pierce the corporate veil in the strict sense, but they did elucidate on the rules associated with piercing the corporate veil. So they found that the companies held the properties on resulting trust for Michael Prest, and the ruling by Lord Sumption was very clear that the doctrine of piercing the corporate veil should be applied only in exceptional circumstances, where the company is being used as a mere facade to conceal wrongdoing. But they concluded that in this case there was no need to pierce the corporate veil, because the properties were not necessarily held by the companies as their own properties. The companies were in fact trustees, and the companies were therefore holding those properties on trust for the benefit of Michael Prest, the beneficiary of this trust. So it was actually Michael Prest who had equitable interest in this property, even if the companies had a legal interest in the property, looking at the nature of the trust more generally.